which has defaulted in repayment of public deposits or the interest and has also not filed the annual return or the balance sheet for the last 3 consecutive years, then that person is disqualified to become a director in any other public limited company for 5 years. So this is an important disqualification. So don't become a director in a company which has defaulted in repayment of deposit or defaulted in depositing the annual return or the balance sheet with the registrar.
Sir, if I am not wrong,
Yeah.
3 years or 1 year, 3 years for balance sheet and
3 years for balance sheet and 1 year for 1 year, yes.
deposit.
Correct. I stand corrected.
Debentures.
1 year for the debentures or the deposits, but 3 years.
And dividend also.
And 3 years, interestingly, the word which is used is 3 consecutive years.
3 consecutive years for last.
So therefore, supposing there is a break, so for 1
Yeah.
year the company has filed, next year it has not filed, then next 2 years it has not filed. So in all there is a 3 year, but they are not consecutive.
They are not.
So you are free to become a director.
It's for the annual return, not for the balance sheet.
Even for the balance sheet also, 3 consecutive years. Same provision is there for annual return as well as the balance sheet. Okay, vacation of office by directors. There are certain, if you become insolvent and all those kind of steps which is there, so you deem to vacate. This is another one thing which is important in vacation is that if a director does not attend 3 consecutive meetings of the board of directors, 3 consecutive meetings of the board of directors, then he vacates his office as a director.
Automatically.
Automatic vacation. So what is the solution? Supposing every time a board meeting is called, it is not convenient to you, you are not there, you are busy somewhere. So the answer lies in that you have to seek leave of absence from the board. The moment a notice comes and you feel that date is not comfortable to you, please write back to the secretary of the company or the board of directors saying that please grant me leave of absence. If you have taken the leave of absence, then it will not be counted as absence.
And there is no restriction in taking number of leave of absence.
There is no restriction in taking.
You have to just make a format and keep it in memo.
Yeah.
But then in the corporate governance report which is being circulated in Hindustan Petroleum also, it says how many meetings have been held, who has not attended. So how many you have attended? So if it says you have attended nil, the shareholders will ask a question that you are an independent director, why did you attend the audit committee meeting or any other meetings? Okay. Removal of directors, yes, directors can be removed only by the shareholders. Section 284 applies. There are few issues which are there. Audit committees, yes. Now audit committees, there are 2 sets of provisions which are there. One is under the Companies Act and another is under the Clause 49. Now Clause 49, you have read Clause 49?
Yeah, we were discussing about it yesterday.
You were discussing, okay. You have discussed in detail Clause 49?
Yeah.
Do we need to discuss that?
I think we should.
Maybe we should touch upon.
Okay, we'll touch upon that.
Basically,
What I've done is I've got some soft copies in which Clause 49 soft copy is also there. So you'll also get it when they give you a CD. So it will be there in the soft copy also. It's the latest one which I'm giving you. And I've taken it not from the SEBI's website. Please be careful. Don't take it from SEBI's website because it is an old one. Even on the SEBI's website, it is an old one. Take it from the listing agreement of any of the stock exchanges. So that way you will get the latest one. So audit committee's provisions are contained under the Companies Act in 292A and Clause 49 of the SEBI. There is one difference which I would like to mention is SEBI provisions are applicable only to listed public limited companies. I think you know that difference.
Yeah.
This is very important to know. It's not applicable to all public companies. It is applicable only to listed companies. It is not applicable to unlisted companies. So therefore, for unlisted public companies and for the private companies, Section 292A of the audit committees of the Companies Act will also be applicable. But for listed public companies also 292A is applicable. So and their requirements are different. They are not at par. For independent directors and other things, there are some differences there in the Clause 49 and 292A. So you have to see the strictest of both.
comply both.
Comply both. That's all. So you have to comply both. Okay. Notices, meetings, and we'll discuss about audit committees. Notices, meetings, and minutes. No time limit is mentioned for giving the notice. How many days? Length of notice is not mentioned in the Companies Act. Meeting can be called even within half an hour also. But some articles, articles of some of the companies, they mention the notice of 7 days to be given. So whatever, if it is mentioned there, then it is to be followed. minutes, one thing I would like to mention is that minutes, once signed by the chairman of the company, they become prima facie evidence of what happened in the meeting. This is very important to mark. So therefore, normally as a customary practice, it is not there in the law. Meetings of the last meeting are normally circulated and they are ratified in the next board meeting. Of the last board meeting, they are ratified normally as a customary practice in most of the companies. It is done in the next board meeting. So if you find something is at variance, that these things did not transpire in the last meeting, but the minutes say otherwise, then please, as an independent director, it is your duty to point out in writing. Don't remain silent, otherwise you can be held liable tomorrow. So whatever is there, please point out, and once the chairman signs it, it will be prima facie evidence of what happened at that meeting. So after that, you will not have no chance to say anything. There are certain statutory registers to be maintained, so legal due diligence will also cover this. Whether the company is maintaining proper minutes or the proper statutory registers. Like there are certain statutory registers which are to be maintained. Like minutes is also a statutory record, statutory register. Then there is a register of directors, section 303, section 300. There are separate registers which are there. If you want a complete list, I think I can provide you a small ready reckoner on the Companies Act, which I can mail it to you.
Sir, I have
If
a
have
question
it-
on
yeah.
place of holding meeting.
Place of holding which meeting? The board meeting or
Everybody
the,
is specified.
the board meeting or the
So
general
the
meeting?
board meeting is not.
Board meeting can be held anywhere in the world.
Video
Anywhere
conferencing.
in this in the world. Of course, not in the universe.
Video conferencing है. Video conferencing है.
Quorum के लिए quorum is not physical.
It's not specified.
Electronic voting.
No, quorum is required physically. Quorum will not be counted if it is on teleconference.
किसी वाले को काउंट नहीं करते forum.
Even on telephone, then people do that, but they
No
do
video
not
conference.
not even video conference. It's
Now,
not
his
allowed.
question is that there are certain requirements under the Companies Act to hold a board meeting within a particular time. It's a 4 times in a year that every quarter one meeting should be held. That is there. Now in the Companies Bill 2008, it is coming that the gap between one board meeting and other board meeting should not be more than 4 months. 120 days it is coming now. But anyway, that provision is not there. So every quarter means the calendar quarter, every calendar quarter, company is supposed to hold a one board meeting at least. Now he says, supposing in one quarter the notice is not issued, then what is my liability or duty as an independent director to do? So the point is you have to look at the articles, who can call the board meeting. That's one. If any director can call, you can also call. Right? If other directors fail in their duty, then it is your duty also to call a board meeting. That you can do. But normally what happens is, normally the meeting are normally called by the chair. The person who is designated as the chairman, he calls the board meetings. So you can write to him, if he has been given the power to call the meeting, then you can always write to him that yes, there is a default, please call the board meeting. Or if there is any burning issue which you want to discuss, even if the time has not expired, you want to discuss anything, you can always say, please call an emergency board meeting on this issue. Or please discuss this issue in the next board meeting. It should be a forming part of the agenda. I'm going to even to that extent. Not only calling, you can also always tell him that please do that into the agenda. Make it as a part of the agenda. So you have to read the articles and also look at the questions. Managerial personnel, actually in the Companies Act, managing director, whole-time director, they are known as managerial personnel. As said, that is the one term which is normally used. Okay, dividend. Can you define dividend?
Distribution of profit.
Distribution of appropriation of profit. What do you say? I've got a very simplest definition. Divide the end.
Divide the end.
The end profit. Divide the end profit, it is dividend. So that's about it. There are certain strict provisions relating to dividend also. And this is to be paid within, you see, if it remains unpaid for a period of 7 years, it has to be deposited with the Investor Education and Protection Fund, which is maintained by MCA. Accounts. Now, accounts is very important. Accounts are to be maintained by the company. Proper books of accounts should be kept. That is the word which is used in the Companies Act. You have to fix the responsibility of somebody that yes, this is the person, the finance director or any employee, he is responsible, or chief financial officer, he is responsible to maintain. Loans and investment, 372A section deals with that. I don't want to go into the details. Director's responsibility statement. If you have, you see, looking at this particular director's report which is mentioned in this book, there is a one statement, director's responsibility statement. There are 4 items or 5 items which are there. So every year the board of directors will have to state, yes, we have done this, we have done this. This is a positive responsibility statement. So it fixes your responsibility also. Operation and management and winding up not taking those are not relevant for the independent directors right now. Okay, now in the corporate hierarchy, this is the hierarchy. Is it clear? Everything is clear?
Yeah.
I think we already discussed this. Yes, sir. Please have a look at this. This is the corporate hierarchy which you are wanting.
They are equal directors, managing director and committees.
Yeah. Directors will not report to MD, or neither MD will report to the director. MD is reporting to the board of directors. So these 3 directors, MDs and committees are reporting to the board.
Board of
They are
directors.
deriving their powers from the board.
Okay.
MD is not deriving power from the director. Director is not deriving power from the MD.
When you say board of directors, can you sorry? It actually means the managing director and the other directors. Which is
Yeah. Board of directors is a consolidated term for all the directors.
What is the difference between managing director and directors?
Managing director means he manages the company, he is into day-to-day affairs of the company, he enjoys a substantial part of the money, he can hire and fire people, which a director may not do.
See, managing director has to be a full-time.
In other terms, he is a whole-time director.
Director.
He's a
A director can be.
Because there is a restriction, you cannot be a MD of more than 2 companies. 2 companies तक allowed है, तीसरी कंपनी में बनने जाओगे तो सेंट्रल गवर्नमेंट की अप्रूवल चाहिए. That's the question. But you can become director in 15 companies, so this is the difference.
But MD cannot fire other directors. It doesn't
No, not at all.
They are not working
Not
under
at all. Even board cannot fire.
Only shareholders.
Only shareholders can fire. Even board cannot terminate. They have to give him a notice of 15 days. He can have a representation, and only in the shareholders meeting he can be terminated.
The logic can be that since directors are being appointed by the shareholders.
Yes.
So then they have the
Only
power
the person who has got the right to power to appoint somebody, he can only fire.
When somebody has to resign, the director has to resign.
Oh, then he resigns from the day which is mentioned in the letter. Now this is again a controversial question. Supposing I have resigned, board says we don't accept. Whether he is deemed to have resigned or not, the answer is quite logical because depending on the past precedents, authorities in the court cases, it clearly says if a date is mentioned in the resignation that I am resigning with effect from so and so date, then the resignation will take effect from that date. If no date is mentioned, then the date of tendering of the resignation will be treated as the date. So that's very clear. There are decided cases because there is a lot of controversy which was there in this.
You said MD, you cannot be MD in 2 companies, but you can be MD in one and normal directors in 14 others.
Yeah. Normal director.
Okay. So second question is shareholders. When you say directors can be fired only by the shareholders, but what happens in the public company? The shareholders are multiple. It's like thousands of shareholders.
In the AGM, everybody has to come together.
So that's
That is the fallacy, or whole fallacy lies in this only.
Yeah.
Because in a company like Reliance, there are more than 6 crores of shareholders. They don't come and attend the shareholders meeting. Who controls? The promoters.
yes, promoter becomes the shareholders.
Whether he is holding 10%, 15%, 51%, 75%, the promoters are running the companies.
Majority.
Actually, that is a major fallacy in the democracy of the corporate hierarchy. It's the very most unfortunate part. Though we treat it as that it is democratic setup, unfortunately it is not. But this can be rectified by various means like postal ballot. You make it mandatory. Sitting at my home, I would not like to go to a factory place. आजकल registered office जितने भी हैं वो बड़े remote villages में हैं. You would not like to go there and spend your 3 days at your own cost. Nobody is paying you for that. Why will you spend that much of time? So therefore the answer lies in if you are given a power for a postal ballot, आप घर पे बैठे assent or dissent लिख दें अपना resolution and you mail it to the company. Electronically also it should come now. It should come any day. Only that is the only solution now. Okay. Director, this is the definition which I have already given, includes any person occupying the position of director by whatever name called. Number of directors. How many number of directors?
But then there also, sorry to interrupt you on
Yeah,
the
yeah,
same
please.
previous point, but there also since few directors, 1/3 of it is always going to be permanent, their name for again will not come. So
Correct.
you will not be able to vote them out at all.
No, you may not be, they are not retiring by rotation, but you
Yeah.
can remove them. A resolution for their removal can still be passed.
No, but when the AGM agenda itself, in that it has to be there for.
Yes, it has to be.
So that they will not put that.
No, they will have to put it if the
Shareholders
shareholders
raise
want
it.
them. Where have to put it?
So how do the shareholders say
There
that
is
they
a
want them? And how many shareholders have to
That
say?
is a question. That is
If
a
one
question.
shareholder says that
No,
please put this on the agenda,
not
it
at
will
all,
not happen.
not at all, not at all. 1/10 of the total voting power. Shareholders holding 1/10 of the total voting power.
Have to give it in writing saying that.
So you have to join 1/10, 10% have to join together to give a notice. Again, a difficult proposition. I agree with you. In a widely held public company, large company, it is difficult. It's difficult.
And how many percentage have to vote for that for this removal to happen?
For removal,
It is not
51%.
very
Simple
difficult.
majority.
Frankly, if you take Satyam,
Yeah.
there are so many institutions who are on the board also, or who actually hold 10%, or 2-3 institutions would be holding 10%.
Correct.
They can definitely.
They can do that.
I can understand that 6 crore shareholders cannot, but
But the institutions can do that.
Yes, yes.
Absolutely. You must have heard about 1986 case, LIC versus Escorts. LIC was holding more than 26%, and Swaraj Pal wanted to grab Escorts at that time. Of course, at that time nobody has heard of, acquiring or acquisition or those kind of things. That was, you can say, hostile takeover which he wanted to do, and LIC prevented that by siding with the Escorts management.
Yeah. So, sir, how many percentage of the shareholders have to then vote so that it can be
51%. 51%. Simple majority. More than 50%. I will not say 51%, more than 50%. Majority. It can be 50.1% also.
Of the casted votes.
Of the casted votes. Correct. If the total people who are present are, say, 120, so 61 have to cast in favor of their removal. So that's the. Okay. So number of directors in a public company.
It has nothing to do with the percentage of holding then.
No.
The percentage of holding is only at the time of asking that you have to.
Now
put this in the
I'll
agenda.
clarify that also. Now since you are asking deeper question, I'll have to clarify. In the AGM, the voting is done by two means. Companies Act says at the first instance it will be done by show of hands. Everyone who is present, whether I am holding 1,000 share or 10,000 share, I'll have only one vote. In show of hand, I've got one. Supposing 20 people are sitting here, I'll say, how many of you are from finance? So only 3. So that's not a majority. Whether I'm holding 10 degrees or 7 degrees doesn't matter.
Correct.
That doesn't matter. So that is at the first instance by show of hands. If the minimum 5 persons can ask for a poll, ballot. So if 5 shareholders who are personally present there, if they ask for the polling to be done, not by show of hands but the balloting, then it has to be done by ballot. Then your votes are in proportion to your shareholding. Then it is not one for every person. It is, supposing you are holding 10,000 shares, then you have got 10,000 votes. And a person who has got 100, he has got 100 votes. And then interesting portion is that you can divide even this 10,000. Out of this 10,000, you can say 6,000 in favor, 4,000 against. You can even divide that also. It is democratic even to that extent, but unfortunately it is not happening. Not happening. That's it. Okay. Shall we move forward now?
Yeah.
Now, in public company, minimum 3 directors are required, and in what is the maximum limit?
12.
15. Maximum is 12. Private company, minimum 2. Maximum is 12 for both private and public both. But if you can have more than 12 also, provided you obtain the central government. I am a director in a company which has got 27 directors. You may ask which company now, which has got such a large board. It is Delhi District Cricket Association, it's DDC, who are conducting this matches there. Yeah, okay. Now, position of a director. Is he an agent of a company? Do you think he is an agent of the company? Okay, what he is, suppose, let us forget about agent. What is the position of a director?
Representative of the shareholders.
That is there, correct. But is he an employee of the company?
No.
Is he an agent of the company? Is he a trustee of the company?
He is a
Is
trustee
he a
of the
custodian of the shareholders?
Yes.
The answers are yes. Okay, let us look at it. I think we know the answers. Company acts through its directors.
Yes, sir.
So directors in a way become agents because the company becomes principal, the directors become agent in a way. They can hold company responsible for certain acts. Supposing as a director, if I buy a ticket in the name of the company, air ticket, company is bound to pay that. That's a separate issue that it will be a dispute between a director and the company whether that ticket was required or not. That's a separate issue. But I have made the company bound by these kind of things. So principles of agency do apply. So he is treated for a limited, and the contracts which a director is entering in the name of a
company.
And this is what the agent does. Agent also always enters into a contract in the name of the principal. So director also does that. So to a limited extent, yes, he is an agent of the company. Is a trustee? Yes. All the directors, the powers are in the power of trust, good faith, due diligence, benefit of the company as a whole. And employees may work as an employee, like if he is working as an MD, he is an employee. He is getting PF.
All whole-time directors are employees.
Are employees, yes, have to be employees. So may work as an employee. Not necessarily, but yes. Direction, okay. Now, what is the job of the board of directors? They lay down the policy decisions. There's a difference between policy and procedures. So they lay down only policy guidelines that yes, this is to be done, this. And the way in which it is to be done will be decided by the management. What is to be done is decided by the board. How it is to be done is decided by the management. And management is one rank below the board. Board is also included in the part of the management, no doubt about it, but they are more likely to be covered in the governance. So this is the difference between governance and management.
Does management have a definition?
It does not. It does not have a, management does not, but simply defined, the person who manages or the person or the persons who are managing are nothing but the management.
And those who direct are directors.
Those who are directing are directors.
So board is a director.
गवर्न बोलेंगे तो गवर्नर हो गए सर नहीं आजकल गवर्नेंस ही यूज करते हैं ना कॉर्पोरेट गवर्नेंस और देखिए यही कॉर्पोरेट गवर्नेंस के ऊपर भी स्लाइड्स आई थिंक विल मूव फर्दर
कवर भी किया है सर जिनमें गवर्नेंस
कवर कर लिया ना ठीक है तो आई विल स्किप दोस इफ वी हैव ऑलरेडी कवर्ड देन विल नॉट रिपीट विल नॉट बी रिपीटेटिव सो व्हाट इज टू बी डन एज अपोज्ड टू हाउ टू बी डन दिस इज नॉट एज डायरेक्शन ओके ओनरशिप that means ownership means shareholders. Shareholders means that indicates control. The persons who are responsible for direction are accountable to owners. Board of directors are accountable to shareholders, but on paper only. Of course, on paper only. Members of the shareholders. Ownership means members of the shareholders of the company. Now governance. Okay, let us. If we have done this, I will not deal with it in a longer this thing. Now derived from a Latin word, which means to rule or to steer. It's like driving a company, steering a company. These are only highly technical ones. Okay, let's move on to governance vis-a-vis management. Let us look at the difference. Governance is strategy oriented, and that is the task oriented. Framing of policy, execution of tasks. External focus, focus is internal. How to run the company is internal focus. How to run the company for stakeholders is the external focus. Now the stakeholders come. That comes under the purview of governance, not in the management. Management is not really concerned about the stakeholders. They are concerned about the working of the company in accordance with the guidelines. But this is, I think, this is true, isn't it? But is vice versa true? Will better management lead to better governance?
Not
Always.
necessarily.
Not necessarily. Correct. I agree with him. Not necessarily. But better governance will certainly lead to a better management.
Yes.
No doubt about it. If you govern better, there will be a better management. Okay. This is basically, I think 3 things are included in corporate governance. One is sound management, transparency, and disclosure. Now these are very, very important words. These are not only technical words, these are important things. Now these are few words of the past president of the World Bank. We are already at 1 o'clock.
Yeah.
Oh my God, we'll be overshooting time. We are not sticking to our time. What do we do then? Okay. What is the lunch time? No, we'll certainly use that, but we cannot curtail that. Obviously, the lunch is also
सर आप इसको कंपनी एक्ट को पूरा कीजिए
ठीक है।
फाइनेंस वाले में थोड़ा कट शॉर्ट कर लेंगे
इसको कवर करने में भी कम से कम आगे